A few moments
All
later.
right, that's fine. I will let you make some closing arguments, but let's keep them pretty focused on what we're doing. If you can, please, and you may begin, Miss Carter.
Thank you, Your Honor. We believe that the evidence has shown that an MSA was entered into with Ms. Deja White and signed by Ms. Wheeler, indicating that Ms. White failed to comply with the provisions of a court order that specifically.
But don't talk too fast, because then we can't get a
I'm
record.
so sorry. Um, specifically established the actions necessary for Ms. White to obtain the return of her children who have been in the permanent or temporary managing conservatorship of the Department of Family and Protective Services for not less than 9 months as a result of the children's removal from her under Chapter 262 for abuse and neglect of the children, that Ms. White agreed that termination of her parental rights is in the best interest of her children. The signatories of the MSA also agreed that termination of Ms. White's parental rights were in the children's best interest. That was further supported by the testimony that Ms. White, in fact, did not complete her services that she was ordered to complete. The officers indicated ongoing involvement with law enforcement. Ms. White did attend therapy, and her therapy goals were not met. There was a lack of accountability or substantive change in thoughts and behaviors. Ms. White was aware of the need for her to leave her mother's home in order for a plan to move forward with placement of at least Kamari in Ms. Wheeler's home, and Ms. White had yet to leave that home. Ms. Wheeler was informed of what would be needed in order for the department to move forward with the placement of Kamari in her home, and she did not take proactive steps to make that happen and did not make any formal requests for visitation with the children until after Ms. Burdett's attorney filed a motion for further orders in this case. A potential placement with a failed home study and a failed kinship safety evaluation must take some accountability for remediating the concerns raised in the home study and seek out available alternatives. The court was available to all parties to seek a contested placement hearing to override the failed home study, and no such hearing was requested. The department's focus has to be on the children and meeting their needs. If a potential placement doesn't make an effort, the department should not be held responsible for the inactions of others. Ms. Wheeler did not even reach out to the placement for the two younger children, even though Ms. Trevor provided contact information and would have been open to virtual visitation or transporting to an improved visitation location. The onus for resolving the issues that caused the home study to fail and the kinship safety evaluation to fail has to reside with the potential placement. The department is available to assist with families, but not to do the work for them. The unknown father and Mr. Clark were appointed attorneys and each filed diligent search reports. No man has come forward to claim parental rights of Kamari as evidenced by the paternity registry search and vital statistics search, as well as no father being present for this trial. Both the unknown and Mr. Clark have failed to register with the paternity registry, and Kamari was over the age of 1 at the time of the filing of the petition for termination. The evidence has further shown that Byron Williams failed to comply with the provisions of a court order that specifically established the actions necessary for him to obtain the return of his children who have been in the permanent or temporary managing conservatorship of the Department of Family and Protective Services for not less than 9 months as a result of the children's removal from the parent under Chapter 262 for abuse and neglect of the children. And it is in Camilla and Deshawn's best interest for those rights to be terminated. The evidence has shown that Mr. Williams has expressed to witnesses that the children are being well cared for in their current placement, and he expressed he would like them to stay in their current placement. Mr. Williams was court ordered to complete services, and no services have been completed at this time. Mr. Williams has continued to exhibit assaultive behaviors during the pendency of these cases and has continued to have law enforcement involvement. Mr. Williams has not demonstrated significant changes in regards to the reasons that his children came into the care of the department. The department's plans for these children are not yet solidified. Kamari, due to his special needs, has not yet achieved the permanency that the child advocates would like to see. However, there is an imperfect plan for him. The plan is to continue to work with the therapeutic providers and continue to seek out professionals that can provide the best insight into his needs based on his diagnoses. Once the information is available on how best to serve Kamari's needs, then appropriate long-term placement can be sought. His current licensed placement for his current level of care may not be a long-term option, but he is surprisingly doing well in that placement. The information gathered there could be beneficial in being able to assess his readiness to either be placed with Ms. Wheeler, or if it is in his best interest and Ms. Trevor is appropriately licensed with Ms. Trevor and his siblings. It is unfortunate that the information needed to make those informed decisions is not available today, but all child advocates are working to ensure his needs are met. It is clear that Ms. Wheeler is not in a position as we sit here today to have Kamari placed in with her, as evidence has shown that she intends to move soon, and Ms. White is currently in her home. The lack of stability regarding those issues makes an immediate move of Kamari untenable at this time. However, the department is open to reassessing Kamari's placement as appropriate. As it relates to Camilla and Deshawn, the evidence has shown that they are doing extremely well in their current placement, and that placement is open to maintaining safe and appropriate communications and contact with the family of origin moving forward. The current placement has been able to provide for Camilla and Deshawn's needs and is prepared to adopt them should the parental rights be terminated. Ms. Trevor continues to provide for the children's needs, is open to preparing a place for Kamari if that becomes a viable option based on his needs. Ms. Trevor has demonstrated that she is a foster parent willing to go above and beyond, and it is the department's plan to move forward with adoption by Ms. Trevor as it relates to Camilla and Deshawn. Ms. Trevor continues to support sibling connection even if the children remain in two separate placements. The department is requesting that the parental rights be terminated as to Ms. White under 161.001 B10 and 161.001 B2 for failure to work services and in the best interest of the children. The department is also seeking termination for the unknown and Mr. Clark for failure to register with the paternity registry under 161.002 B2. And as to Mr. Williams, also under 161.001 B10 and 161.001 B2 for failure to work services and in the best interest of the children, and further requesting the department be named permanent managing conservator of all three children, making them eligible for adoption and all the benefits that may come with that the current placements be maintained, and that this case be referred to the PMC docket. Thank you, Your Honor.
Thank you. Ms. Crouch Bartlett.
Thank you, Your Honor. Based on the testimony and evidence presented over the last 2 days, I think it is clear from the evidence that Trinice Wheeler should be named as the managing conservator of all three of the children, and that a transition to her home should occur over the next month and a half to ensure that all of the children are integrated into the home successfully, and that the department should assist with that in any way that they can, and that the child advocates have access to the home so that they can ensure that the home is appropriate. But I think that it's clear that Ms. Wheeler should be named as managing conservator. Thank you.
Thank you, Mr. Hagerty.
Thank you, Judge. I will be brief. As you heard in my opening statement, my communications with Mr. Williams and my discussion of this case with him have led me and him to the point where he is of the opinion that his children, Camilla and Deshawn, are in very good hands in the foster home with Ms. Trevor. He strongly supports her adopting the children, and he knows that they will be safe and well taken care of. Thank you, Judge. That's all I have. Thank you.
Thank you. Mr. McGivern.
Your Honor, I would echo the points made by Ms. Crouch Bartlett and say that Ms. Burdett fully endorses Ms. Wheeler's request to be managing conservator for these children. And I mean, in addition to all of the valuable parenting skills and assets she brings to the table, I think the alternative is that the department doesn't have any realistic plan for Kamari to achieve permanency, barring placement with Ms. Wheeler. And given her resources and her abilities, it doesn't make any sense to split up the sibling group.
All right. Thank you. Ms. Anderson.
Your Honor, at the yesterday morning, you said that you weren't sure that it was going to be in the best interest of these 3 children to terminate the mother's rights. I think that the evidence has amply demonstrated that it is in the best interest to terminate the mother's rights. The question of whether these 3 children should be, whether Ms. Wheeler should be given managing conservatorship and the children immediately transition to her. I think that the foundation for a decision like that is based more on the unfortunate fact that the department did not work this case very well. In fact, I think that there wasn't enough support for this family, as is the case in pretty much every single case, CPS case. There's never enough support for the family. There's never enough resources. There's always a wait list for services. And yeah, the families themselves don't always have the resources that they need, and they don't know how to get the resources that they need. I think it would be an injustice to Camilla and Deshawn in this case for a decision to be made to give Ms. Wheeler managing conservatorship of them at this point when everything has been proceeding along the lines of Ms. Trevor taking extremely good care, going above and beyond, and in addition, preparing to adopt these children while also being totally committed to maintaining their connection with their biological family. She has been very open and worked well with the biological family. We didn't hear any testimony from a child's therapist as to the child's desires or the bond, how bonded they are to Ms. Trevor, but you can imagine as young, tiny, traumatized children, they have found security with Ms. Trevor. I think that if Ms. Trevor is permitted to adopt those children, you will not be seeing those children or this family in this courtroom again. I think that if Ms. Wheeler has managing conservatorship, I think that this family could very easily be back in this courtroom. I'm asking that you terminate parents' rights and award PMC of Camilla and Deshawn to the department with the plan for the case to move into the adoptions unit and for Ms. Trevor to adopt. Ms. Trevor has also expressed that she is willing to be the placement for Kamari, should that ever come about. And so again, I think she would be happy to have Kamari and Camilla and Deshawn visit grandmother. I could see that developing into a really healthy relationship, but to yank them out of the placement where they have finally found security and home at this point, when Ms. Wheeler has had the ability all along to do what needed to be done to have them placed with her, and she's never done it. And I understand it's a Hobson's choice between, kicking your daughter, who is not really able to adult, she's not adulting at this point. She's 25, and a lot of 25-year-olds are not adulting at this point. Believe me, I know. But I don't know when that's going to ever happen. And to kick your daughter out, I don't know that she's going to be able to do that. Thank you.
Thank you. I'm going to skip to Ms. Lozito and then finish up with Ms. Wheeler. So Ms. Lozito.
Yes, Your Honor, I am in agreement with Ms. Carter, and I'm in agreement with Mr. Haggerty and Ms. Anderson. The only kind of in the alternative I'd like to offer, I do think PMC to the department for all 3 children is appropriate. I understand the hesitation around Kamari. I've had the same hesitation. I've been on this case. You know, I took it over very shortly after Colin was the original attorney from our firm. Kamari has always been my biggest goal. And I would be in agreement with PMC to the department with the caveat that placement moved to Ms. Wheeler as soon as possible to see if it works, because Kamari's already been given up by 2 family members. And my concern is that primary managing conservatorship at this time, moving all 3 children at this time, is going to result in an instability in which, like Ms. Anderson mentioned, we're going to end up right back here again. So I would just, in the alternative request that if PMC is granted for all 3 children, that placement is Ms. Wheeler as soon as she is able to take Kamari. But I do not agree with PMC or sole managing conservatorship to Ms. Wheeler, because he's already had such instability within this family unit. And I'm really just trying to figure out a way to make sure that we are not in that same position moving forward. Thank you.
So I want to be clear at what your suggestion is, Ms. Lozito. So your primary request is termination of all 3 children's parental rights.
Yes.
I said that backwards, but you know what I mean. Okay. But you're saying if I don't do that, then your request is that I grant the department permanent managing conservatorship and not terminate for all
No,
3
my
children.
request is permanent PMC to the department, but that placement does not continue for Kamari. That placement changes to Ms. Wheeler for Kamari. So placement remains the same for Deshaun and Camilla.
I'm just confused because what I heard you say is I would support an alternate decision of PMC for all 3 children to the department. Did I mishear you?
Yeah, I might have just misspoke, because what I am in agreement with is termination and PMC, which is what Ms. Carter asked for, but she asked for all placement to remain the same. I think in the alternative, PMC to the department on Kamari, but placement to Ms. Wheeler is appropriate based on the circumstances.
So your position remains termination even for Kamari.
Of parental rights for Kamari, yes.
Okay, all right. I was wanting to make sure I understood. Okay, Ms. Wheeler, would you like to make a closing argument? Mostly just focus on what it is you're asking me to order today.
Can you hear me?
I can.
Okay. Again, I just need the time to move. I don't have problems with taking care of my grandkids. My grandkids will be in my care. To me, I've already lost one grandchild. So the thought of losing all 4 of my grandkids is just, I can't. I need my grandkids with me. Again, I would not try to break them up from Miss Trevor or even from their father. I spending nights over, the weekend over. I don't have a problem with that. My only problem is that everybody is trying to keep my grandchildren from me because I didn't know that I was able to intervene and how I was able to intervene. That's all I really have to say.
All right.
I just wanted to say that when we did have that one meeting at the courthouse, that's when I became aware by Miss Crouch Bartlett that I was able to intervene. So I went directly across the street when we finished and did the paperwork, came back, got it filed, and did all the necessary things that I was supposed to do because I was then aware I was able to do that. And that's all.
All right. Well, I appreciate that. I certainly can understand a family member not knowing what their options are. There are lawyers who practice in this area who don't know what your options are. So that is not a surprise to me that it is a complicated and confusing process and hard for you to figure out. I'm going to take a few minutes. I have a lot of thoughts already written down. I'm going to take just a few minutes to read over them, make sure I am confident in my decision, and then I'm going to come back and let you know what it is. Okay, so we'll just turn our cameras off, hopefully maybe 15. Well, this case is clearly a challenging one. I've been thinking a lot about it, thought about it a lot last night. I've reviewed the pleadings, particularly the various petitions, listened very closely to the testimony over the past few days, and take these decisions very seriously. So I wrote them out. All right. By clear and convincing evidence, the grounds under 161.001 B10, so those are the failure to complete court-ordered services grounds. I do find that those have been met for Deja White and Byron Williams. For Mr. Clark and I do find, I think it's you correct me if I'm wrong, Ms. Carter, but I think it's 161.002 B2B. For him, and for any unknown father, it's 161.002 B2A. And again, I find the grounds have been met by clear and convincing evidence. But all of us know CPS cases are a two-prong decision. There's grounds for termination, and then there's for termination. And best interest is always the hard decision. Among the many things that I consider when making a best interest decision are the plans for the child, any special needs the child may have, and a strong preference under the family code to keep children with family members, biological family. Now, obviously, we all know kids don't always stay with biological family, and there are reasons for that. And I consider all of the different factors. This is an interesting case because I was brought an MSA that agreed to the termination of Ms. White's parental rights, but did not address, and actually I want to look at it one more time now that I think about this. What does it say? It doesn't, it's very interesting written. So it says that Ms. White stipulates clear and convincing evidence under the O grounds. Best interest, that she agrees it was not the department's fault she couldn't complete her services, that the department will not move for termination on any other grounds, that the department will not seek post-termination child support, but it doesn't address in any way who should be named the managing conservator of the children. It wasn't, I assumed that you couldn't reach an agreement on that. But it was interesting because I'll admit I spent the beginning part of the morning yesterday thinking there was an agreement on that, but there never was any agreement on that. So I think first I thought maybe some of you were surprised by kind of some of the testimony, but I don't think you were. I think you all knew that you didn't have an agreement on that and that there was a dispute. So I should have read that MSA more carefully first thing yesterday morning, and maybe I would have understood. It took me a little while to pick up on that. Camilla and Deshawn are placed in an adoptive home with a foster parent who wants to adopt them, who, by her own testimony and others, is engaged in efforts to maintain both their cultural connections, which are very important, and their biological family connections, which are also very important. And at the same time, has clearly, and I 100% believe this, taken on the role of a parent in the sense that she has sought out to meet their normal and extra normal needs in terms of therapy, in terms of activities and extracurriculars, in terms of an appropriate response to whatever their needs are. And I was very impressed with Ms. Trevor's testimony. I 100% believe she is doing all of those things. That is not always the case when I hear from a foster parent. So I feel good about you being in their lives for sure. Kamari, on the other hand, is placed in a foster home that will not adopt him, is not interested in being an adoptive placement. He has been diagnosed with a serious genetic disorder that is a lifelong condition, and he is currently separated by approximately 180 miles from his siblings and any of his family. He is placed with another small child in contradiction to his former long-term therapist's recommendation. And of great concern to me is that his legal guardian was not able to tell me accurate or complete information regarding diagnosis, was not able to offer me accurate or complete information about what therapies he or his siblings receive, didn't even comfortably and confidently know the children's ages. And at the same time, based on the evidence I've heard, the department has prevented Miss Wheeler from spending any significant time with Kamari during this case. And those decisions have deprived this court of valuable information about what it was really like in Miss Wheeler's home when Kamari was there, as well as what it has deprived Miss Wheeler of the information she would have gotten from spending significantly more time with Kamari. And given that he was placed somewhere in the Austin area close enough to see a therapist in Burnett, I find this short-sighted and a real failure on the part of the departments, honestly. I get that you had in your heads an idea that nothing could happen because Miss White was there, but I think with some creative work and planning, things could have happened and we could have a lot more information for me to make that decision. I think, Ms. Lozito, that's a great role for an attorney ad litem, because your role is not to do anything except what's best for the children and try to figure that out. And so putting the pressure on to say, hey, this is a kid who is not in an adoptive placement, has never been in an adoptive placement, and has family who wants him. What hearing can I ask for to push this forward and get this information so that we don't come to the end of a 2-year case having no real sense of whether he'll succeed in this relative's home, or no real sense if she can supervise her daughter in the same home, no real sense of what other things could have been done. So I really, really wish that had happened. That's actually probably my most frequent frustration when these, because they only come to me at trial now, is that work that should have happened over the past year or 2 years doesn't happen. CASA as well is in a great position to push for these kinds of opportunities to be taken, to push the department, to push the court, to not let the department's rules and regulations and kind of hardline positions stop all the parties from getting the information they need. And I get why the department has rules. They're a huge agency. They want to have black and white lines and demarcations, but that's not always what's best for children. And so I, as the court, really expect and rely on what we call the child advocates to do their job, which is never a rubber stamp. It is always pushing independently for what the children need. And that includes information about what the options might be at the end of a case. And I know, because I did this work for 14 years, that certainly by the 6-month mark, you have an idea of where you're going. You could be wrong, but you have an idea, and you can start being creative and being forceful and moving things and getting information. And when you do that, quite honestly, you almost never end up in trial, because when you put information, then everyone has to do what's really going on and what's really happening. I mean, I didn't have any trials hardly the second half of my career at all, because we knew everything, and everyone faces reality when you have that information. So I guess I just took 10 minutes to really pour out my frustration about the lack of good information that I have to help me make this decision. All right. On the other hand, or another point that I've been considering, is that as wonderful as Ms. Trevor is, she isn't licensed to be a placement for Kamari. And frankly, she's already got his 2 siblings in her home, and I think was honest and upfront about what kind of commitment that is, particularly for a single parent. I think we saw it today that she needed to leave, which is fine, to go and pick Deshaun up, which is great. I'm glad she's able to do that. But foster families are not magic. They're not magical saviors who can come in and do more than any other kind of families. Now, they should have better training. They certainly have better support, but it doesn't mean they can take on impossible tasks and succeed in them. And in the back of my mind always is we have a recommendation that Kamari not be placed with his children. Now, I have it secondhand, but nobody contested that that was the recommendation. So I believe that really was what was given. And I have the MSA, which in which it is clear that everyone agreed Miss White's parental rights should be terminated. So here is what I'm going to do. I spent a lot of time thinking about this, but I do find by clear and convincing evidence that Deja White and Byron Williams' parental rights to Deshaun should be terminated, and the department should be named permanent managing conservator of Deshaun so that Miss Trevor may adopt him. I'm going to come back to that in just a minute. For Camilla, Deja White and Byron Williams' parental rights, I find by clear and convincing evidence, should be terminated. They are terminated, and the department is named permanent managing conservator of Camilla. And I fully expect the adoption by Miss Trevor to take place as rapidly as possible without a 6-month waiting period, so that she can be free to include their biological family as she sees appropriate. Miss Trevor, I've been in this situation with other families, with foster families who swore, as you did, that they believe in biological connections, that they will work to maintain them. And I have been lied to. I feel like you were telling me the truth. I really hope you were. I hope that Helping Hand is a good foster agency. I have a lot of experience with them. I know their training is extensive and goes way beyond we're going to bring you a baby and you're going to run off into the sunset and the child will never misbehave again, that some foster agencies engage in. I know that they teach you real things, including that children need to be told the truth. They need to have connections with their biological family if they can, and that they will be healthier if those things are maintained. And that parents' jobs, all parents' jobs, are to put their kids first, even if it's painful for the parent. And I think for a foster to be adoptive, to be a successful adoptive parent, that message has to really be there. So it's not just Miss White and Mr. Williams, it's Miss Wheeler, it's Miss Burdette, it's taking them to activities, to, I don't know if you go to church, but to the things that they would get if they were living with their family. So I'm counting on you to do that. I hope that Miss Anderson is right, and I never see those two kids in court again. If I do, I worry about any foster family in the future in my courtroom, because it's just, I've been burned a lot and I just really want what's best for them. So that's the decision for them. For Kamari, Christopher Clark's, I do find by clear and convincing evidence that Christopher Clark, has he any parental rights to Kamari, they should be terminated in Kamari's best interest. And for any unknown father of Kamari, whatever parental rights an unknown father may have, it is in Kamari's best interest by clear and convincing evidence that they be terminated. I do not find by clear and convincing evidence that Miss Deja White's parental rights to Kamari should be terminated, and I do not terminate her parental rights to Kamari. I name Ms. Wheeler permanent managing conservator of Kamari, with all exclusive rights and decision-making ability for Kamari. Ms. White is named a possessory conservator of Kamari, but is not given any decision-making rights under the code. And then here, she is given the rights to information. She has the right to attend school and public functions. That means like, graduations, plays, football games, whatever that Kamari may be at, she can attend those. Her visitation at this point is supervised. But I am giving Ms. Wheeler the right to make the decision about what kind of visitation Ms. White has with Kamari. Ms. Wheeler does not have to consult with Ms. White before making decisions in Kamari's interest. She'll be in charge of that. And I want to talk for just a minute. I have a few more orders for the department, but I want to talk for just a minute, Ms. Wheeler, about why I'm leaving Ms. White as a possessory conservator, but not giving her decision-making rights. I don't know your ability and capacity to adopt Kamari on your own, and I don't believe the department will help you. And the problem with being named a permanent managing conservator of a child is that if the department were to get involved in his life again, if you're not a parent, adoptive or natural, you are not entitled to a court-appointed attorney, which you know from this case, you're a grandmother, you don't get a court-appointed attorney. I believe strongly that you will not do anything to bring CPS back into Kamari's life. That doesn't mean CPS won't come back. He is a child with a lot of special needs. He's going to be involved with a lot of professionals. Some of them are going to have barriers to cultural understanding or have misunderstandings or just report more quickly than they should, bringing potentially CPS back into your life. With Ms. White as his parent, she will be entitled to legal counsel if they get involved again, and that person may be able to help you if Ms. White wants them to. She'll be directing them. So that's one of the reasons why, if you and Ms. White can get the help you need and agree to an adoption, I would not oppose you adopting Kamari at all. Okay. The department is ordered, and I want to make this really clear, Ms. Carter, you are personally ordered to make sure this happens. We're not just going to tell the caseworker to do it and hope it happens. Okay. The department is ordered to provide Kamari's complete medical records to Ms. Wheeler, digitally and in paper form, for the entire time he has been in the care of the department. The department is ordered to assist Ms. Wheeler in establishing Medicaid health coverage for Kamari. The department is ordered to provide Ms. Wheeler with complete contact information for every provider Kamari has seen while in the care of the state. That includes the therapist in Bastrop, whoever did the genetic testing, anyone he has seen, phone and email and address. The department is ordered to provide complete information regarding any waiting lists Kamari is on to see a specialist and any other specialists that have been identified that he needs to see. The department is ordered to assist Ms. Wheeler in applying for Social Security disability for Kamari. They must provide complete records and information that she may need for that process, both digitally and on paper. I'm severing Kamari's case from the other two children's case so we can have separate final orders in them, and then Kamari's won't be sealed the way Camilla and Deshawn's will. Camilla and Deshawn will proceed to the PMC docket with Judge Martinez Jones. Her staff will reach out for a date. And while this isn't what you asked for, Ms. Carter, I'm going to ask you to prepare both decrees. And
Yes, Your Honor, how would you like to receive those decrees? And do we need a separate order for severance, or is this order enough?
No, we'll need a paper order severing it because we need a new cause number.
It has
My
its own
next-
cause number.
Oh, he does? So
He does have his own
you're
cause.
right, because, so Kamari has his own cause number?
Yes, Your Honor, all three.
Oh, we don't
cases
need to
have a
sever
separate
anything.
cause
I
number.
didn't remember who was combined with who. Then that's fine. We don't need to sever. His will just go on a different path. Thank you. My next motion to enter date is February 3rd. That's only 2 weeks away. I don't know if that's enough time to get all these orders written. I'm happy to push it off until the following one, which is February 24th at 9 a.m.
And would you like to receive these orders as a PDF or as a Word document? And who should I send them to?
If you can get everyone to sign them, like everyone agrees with the form, the language, then a PDF is fine. If you can't, then I need them in Word because I might have to make changes. And you can just you can put them in box and send my staff an email telling me that they're there, or you can send them in an email to Miss Matashek Steele or Miss Ward, put in the subject line that it's post-trial.
Thank you, Your Honor.
I'm really relying on Miss Trevor and Miss Wheeler to become friends and get over their very justifiable feelings, Miss Wheeler, that this is unfair, that my decision is unfair. I will take it. I understand that. I mean, I don't understand it the way you do. I'm not trying to say I know how you feel. I accept that you're upset with me. That is okay with me. It doesn't matter. You have your feelings. Those are okay. What I want is for you to try and put aside your upset feelings with Miss Trevor that you may have and try to develop a really good relationship with each other for the 3 siblings' sake, so that while they won't grow up in the same house, they can grow up together. Because once CPS is out of the picture, the 2 of you will decide what happens with these kids. And that means all the normal decisions, including things like visiting relatives, right? I mean, my children spend the night with their aunt, for example. They could spend the night with their grandmother. They could spend the night with he could spend the night with his sibling's mother. The siblings could maybe spend the night with his grandmother. I know that sounds confusing, but there's a lot of opportunity over the next 12 to 17 years for things to develop and grow in a really healthy way. And I hope that's what happens. All right. Is there any question? If there are questions, yes, Ms. Crouch Bartlett.
Thank you, Your Honor. I just had one question. Would you be making any orders about sibling visits prior to adoption, just to ensure that that happens?
I mean, I can do that. I can order. I mean, I'll probably order like a monthly sibling visit until the adoption. Post-adoption, any of the children can file their own suit, but somebody has to do it for them. So Miss Trevor would have to do it for those 2, or Miss Wheeler would have to do it for Kamari, seeking visitation with their siblings. I'm hoping it doesn't come to that. So let's have a monthly visit among the siblings. CPS doesn't need to be present if Miss Trevor and Miss Wheeler can get together on their own and conduct that visit. But CPS is ordered to help because they're still in the case until that adoption is final. Ms. Carter.
Yes, Your Honor. Are you ordering the immediate transfer of Kamari to Miss Wheeler, or at some point?
I'm not going to order that you go to Houston and pick him up today and bring him back tomorrow, but you need to come up with a plan so that it happens by the time I sign the final decree.
Thank you, Your Honor.
Okay. Which that's why I picked February 24th. That's almost 6 weeks away, 5 weeks, I think. Okay.
Judge, one question, and I may have missed this, and if so, I apologize. And I don't, obviously, I don't represent a client who is related to Kamari, but do we need an affirmative ruling one way or the other on Ms. Burdett's petition to intervene or her pleadings?
I mean, I think I'm sure, I need to pull and see exactly, Mr. McGivern, exactly what did you include in Ms. Burdett's requests? It wasn't a big topic of the testimony today, so I didn't focus on it.
The petition annotates my personal involvement as well. I would suspect in terms of the court's ruling, the simple phrase that all requests for relief that are not granted are being denied probably.
Well, that would go in the final decrees for sure. So to the extent Ms. Burdett sought to be named permanent managing conservator of any of the children, that's denied. To the extent she requested to be named a possessory conservator of the children, that's denied as well. I don't think we need that under the circumstances. All right, if something comes up, you can reach out via email. Just make sure you include all the other parties. All right, I know this has been a really hard day for everyone. I'm gonna let you guys go.